Court today, January the 30th, 2012. Mr. I'm here to set your bond this morning. I don't know anything about your individual case. If you do not understand the law that you're charged under, I'll be glad to explain the law to you. You have a charge of possession of a weapon during a violent crime and also a charge of murder. You have the right to have an attorney present with you when you go into court. If you cannot afford to hire an attorney, I will be glad to screen you to see if you qualify. That will be based upon your income, and then that will be applied to federal guidelines. You have a next appearance date scheduled for March the 9th at 9 o'clock in the morning at the courthouse at 109 Park Avenue, with a second hearing date scheduled for June the 1st, 1:30 in the afternoon at the same courthouse, 109 Park Avenue. You also have a right to what is called a preliminary hearing. What happens in that hearing, the state is prosecuting you. They have to come in and give sworn testimony before the judge to establish a probable cause. What was your intent, your knowledge, your involvement? Did you violate the laws of the state that you've been charged under? If they cannot establish probable cause, then your charges can be dismissed at this hearing, but you can be directly indicted if there's enough evidence to take before a grand jury. This is the form to request that hearing. You will need to turn this in to your attorney or give it to the solicitor on your next appearance date of March the 9th. If you fail to turn it in to one of the parties, then that means you have possibly waived your right to have this hearing. Do you understand the charge of possession of a weapon during a violent crime?
Yeah.
On that charge, if you're found guilty, it can carry a sentence of up to 5 years and or a fine in the discretion of the court. Do you understand the charge of murder? Do you understand the law pertaining to murder?
Yeah.
That can carry up to life, imprisonment, or the possibility of death, according to the law. On these charges, Mr. Do you wish for me to screen you for a court-appointed attorney? Do you have the income to hire an attorney on your own?
Does it look like it?
I don't know. I don't have any idea. I just ask that you answer my questions. Are you currently employed?
No.
Do you want me to screen you for an attorney?
No.
You're going to hire your own?
I don't need one.
Mr. I never advise anyone to go into court regardless of the charge without an attorney. Do you want to be screened for an attorney?
I don't care.
Mr. You say at this time you are currently unemployed. I am going to pre-qualify you for a court-appointed attorney. Someone from the public defender's office will come over and speak with you about your case. Now, on the charges of possession of a weapon during a violent crime, here's a copy of all your rights that I've gone over with you. If the charge is brought against you, if you're found not guilty, if the charges are dismissed or no pros, then these can be expunged from your record, which means they can be erased from your record just like it never existed. Also, if you fail to appear at any of your court hearings, additional charges can be brought against you. Is your mailing address 324? Mr. This is your paperwork with your next appearance date on it. It also tells you that I have pre-qualified you for a court-appointed attorney. I need you to sign that on the bottom line for me, and I'll give you a copy of it.
Sorry.
And
yes, ma'am. We're going to request that the defendant be ordered not to have any contact with the victim's family, please.
okay. Anyone else like to make a statement? Okay. Mr. There is going to be a condition that you're not to have any contact with the family of the alleged victim. Do not call, email, text message, no type of electronic communications. Don't have any of your friends calling and trying to harass them in any way, because you will have to answer to the court if you do. On the charge of murder, because it does carry life or death imprisonment, then I am not allowed to set a bond on that. You have to go before a circuit court judge to have a bond set. I have given you your rights on that charge. On the possession of the weapon during a violent crime, I'm going ahead and setting your bond at $10,000 on that charge. Understand you cannot be released until you go before a circuit court judge to have your bond set on the murder charge, and you also have a hold on you for another county, so even after that bond is set, the possibility is that you will not be able to bond out. I need you to initial on the front stating you understand your first appearance date for me.
You got initial right here?
And sign the back across from your mailing address.
Yes, right here.
Do you have any questions pertaining to anything that I have told you thus far? Okay. All right, so
Thank you.